All right, my clock says 10:01, and I would like for us to go ahead and get started. We have a lot to talk about this morning and only an hour to do it. So good morning, everyone. My name is Beth White. I am the president and CEO of the Indiana Coalition to End Sexual Assault and Human Trafficking. We are sponsoring this session this morning. I hope you saw a minute ago that we are taping. So the tape has begun, and I want everyone who is with us this morning to be aware of that. I am thrilled to be joined this morning by Dr. Carolyn Rouse, who is a maternal fetal medicine specialist at IU Health Raleigh, and who is also a fellow with the American College of Gynecologists, I believe. Do I have that right, Dr. Rouse?
Yes, obstetricians and gynecologists.
There we go. Wonderful. She is a terrific expert and really been very generous with her time for us, not just this morning, but in the context of this legislation that we now have. She and others of her profession spent a lot of time in the legislature, and I just appreciate very much. So I want to say right up front that Dr. Rouse, we appreciate you and your expertise and your willingness to share that with us this morning. So Michael, you are controlling the slides in the back end, so why don't we move forward with the next slide. Let's see, we, as I indicated, only have an hour for our time together today. There are a couple of preliminary things I want to discuss very quickly. Of course, I indicated that the recording is happening. We want to acknowledge right up front that this is a difficult topic. This is a hard issue for many of us to discuss, to be a part of. We understand that many people who are within the sound of my voice may have experienced some of the issues that we're going to talk about today. And we want to make sure everyone understands and knows that they should practice self-care. If stepping away from the conversation is what you need to do, then please do it. And make sure that you, above all, are caring for yourself first. We have a very significant number of people registered for our session today, so I want to make sure that we have enough time for all the questions. So we will be using the chat function of this morning's session to handle the questions. So if you have a question or are interested in putting a perspective or your thoughts into our conversation, please use the chat, and we will make sure that we try at the end to have plenty of time to get to as many questions as possible. Next slide, please. All right, here is the two presenters for this morning. We are going to focus for the hour that we have today on the rape and incest issues surrounding the new abortion law. This law is complicated. There is a lot to say. There has been a lot of reporting around the issues of maternal health and the health and life of the mother and other issues of fetal anomaly. These are very complicated and way outside my expertise, which is why it's so important Dr. Rouse has joined us this morning. But in order to specifically minister to the things we are needing to get to today, the victim and rape and incest exceptions are going to be our focus. I'm going to use the term victim as opposed to survivor. In the work that we do here at the Coalition, we talk a lot about survivors and those who have experienced sexual violence and moving in their journey towards survivorship. But the statutes that we address this morning use the word victim. So that is the word I'm going to use today, and I wanted to make that clear. We have focused this morning's talk on those who are doing direct service and helping those who have experienced sexual violence. And we are going to create, as of the result of this morning's discussion, a frequently asked questions document that will be a living document on our website, which will include and provide opportunities for updating as we go through the implementation of this law, which will occur in a very few short days. So I wanted to make sure all of those things are obvious to those who are participating this morning. Michael will take the next slide. So what is in the new law? The law was signed into law, passed by the legislature in the latter part of July. It's been on the books for about a month, but we know that it takes effect on the 15th. There are some exceptions to what the press is now calling a near total ban on abortion services in Indiana. And those exceptions are rape, incest, health risk to the pregnant woman's life, and lethal fetal anomaly. And as I indicated a minute ago, the last two are not going to be the focus of our discussion this morning. There's a lot to say, and we will hopefully have subsequent opportunities to focus on those particular exceptions. We're also going to talk this morning about the timeframes that are associated with the law and are, I believe, going to be a real challenge for those people seeking abortion services. Michael, let's go to the next slide. So what is not in the new law? Dr. Rouse and I spent a lot of time in the legislature listening to debate. There were a lot of issues brought up and not subsequently codified into the final version. No documentation is needed to be signed by the person seeking abortion care. And that was the subject of significant debate in the course of our legislative process. No rape kit is required for a person seeking abortion services. If you or the person needing abortion services want to seek those services, you are not required to participate in the collection of evidence or to have a rape kit gathered for you or on you, if I could use that term. It's hard to know how to refer to that, but that's not required. No law enforcement involvement is required. There was lots of debate about whether or not a person should be required to report to the police about their rape or incest experience, or file a police report, sign affidavits. All of those things were discussed. That did not make it into the final law, and it's important for us to know that and to understand that. There are no criminal penalties for a person seeking abortion care or for anyone assisting them. Now, it is important to understand that criminal penalties do exist in the law for healthcare providers. And I know Dr. Rouse will have quite a bit to say about that as we continue our discussion. But the criminal penalties that were contemplated for a person seeking abortion care or for someone assisting them, either financially, logistically, with transportation, childcare, other kinds of efforts that were discussed, that did not make it into the final version. So it's important for us to know that. So what does the law say about a person who has experienced rape or incest? 10 weeks from the date of fertilization for that person who has experienced rape or incest. Now, in a minute, I'm going to ask Dr. Rouse to talk to us about how we determined and what is the way that our medical professionals are determining that, but that is what the law says, 10 weeks. What is required that is that the doctor performing the abortion certify in writing that the abortion is being performed at the request of the pregnant person and is the result of rape or incest. That's what the law says. There is no more clarity or requirement that there be any sort of interrogation or evidence collection or anything else. No requirement that the doctor see evidence of a rape or incest. These are really complicated matters, but there was discussion about whether or not there was requirement that some sort of evidence be indicated, but that's not in the final version. So that is all that the law requires, that a person seeking abortion care, that's the only requirement. Now, incest is going to be tricky, and I have tried to do some independent research of this particular law, but what I want us to understand is that the law as it stands defines sex within a family, incest, as a parent, a sibling, a grandparent, a child, a grandchild, an aunt, uncle, nephew, niece, but is silent on the age of the pregnant person. Because when we use the term incest colloquially, we often think about a child who has experienced sex within a family, that child who is the recipient of sexual violence by an uncle or a brother or a grandparent. But this particular abortion law is silent on the age of either participant in the sex within the family. So that is, I think, an important issue that will create some confusion. Finally, abortion can only be performed in the state of Indiana by a hospital or a surgery center that is owned or operated by a hospital. We no longer allow independent abortion clinics to exist for the purpose of providing abortion care. And so it's unclear at this stage whether places like Planned Parenthood clinics or others can exist, whether their business model can be sustained when they're not providing abortion care. That is unclear. So speaking of unclear, let's go to the next slide. What is still unclear? There is a lot that is unclear. And the first thing I think that we really have to focus on that is unclear is what's going to be the process. How will a person who needs abortion care, who finds themselves within the exceptions, that being they are under 10 weeks and that they are seeking abortion because of their experience of rape or incest, how are they going to seek that care? If it has to be delivered in a hospital or a surgery center affiliated with that hospital, how can they seek that care if they are not a patient already of that hospital, if they're not under the care of a doctor or another professional affiliated with that hospital? How are costs going to be determined? So I'm going to stop talking and I'm going to ask Dr. Rouse to address this particular bullet on what's still unclear, which is this issue of how do we know about 10 weeks or below of gestation, and how do we know, or how is a person seeking abortion care going to seek those services? Dr. Rouse?
So you are totally correct in that the process has become so much more difficult for victims of rape and incest to obtain the abortion services that they want and need. And I guess I'll start off by saying also, so I am employed by the IU School of Medicine, but my opinions are my own. So that's out there. So the process, how will it work for someone seeking abortion services? Now they will have to know, be able to find out where those services are being provided. So not all hospitals, not all hospital-owned surgery centers will be providing those services. Using existing pathways to obtain information like the Hoosier Abortion Fund, those things are still going to be in existence after this law goes through, and there are great pathways for information to figure out how to obtain a legal abortion in the state of Indiana that are, going to be available for people. It is not prohibited to give people information about how to obtain a legal abortion in our state or a legal abortion in another state. So in terms of how far along, what gestational age the pregnant person is at, that will, normally we determine that based on last menstrual period and corroborate that with an ultrasound, which can be important for folks who maybe have irregular menstrual cycles or are unsure of when their last period was. Part of the state required consent process for abortion services is that an ultrasound be performed at the time that the consent is completed. And so that ultrasound would be used to confirm the pregnancy dating to ensure that the patient is at or below 10 weeks post-fertilization. It is also sort of a little bit of nuance related to pregnancy care, but the dating language used in statute is not the dating language that we use in clinical care. So in medicine, we don't talk about post-fertilization gestational age. We talk about gestational age after last menstrual period or as determined by ultrasound. So 10 weeks post-fertilization is actually 12 weeks by last menstrual period or ultrasound.
Well, Dr. Rouse has just raised, I think, another example of the confusion that this law is going to result, there's going to be a result, because she's just identified one way, and it's not the only way, that clinical practice is not consistent with what the law indicates. And so how that's going to be reconciled is very troubling and confusing. Dr. Rouse, I know that you speak for yourself, and I also know that you are affiliated with the IU School of Medicine, IU Health, Riley. Can you speak in generalities about how hospitals are working on protocols around how a person will present and be able to get care in a hospital where they may or may never have been a patient, or they might present to an emergency room? It is not an emergency at that point. How's that all going to work? What do you think is going to be the way this is going to work around the state of Indiana?
So there are so many different unintended consequences for both patients and healthcare systems that this law is bringing up. And so how each health system or clinic determines how they're going to implement the new law is going to be unique to that individual setting. Sorry, my cat is like being very aggressive, but as part of a very large healthcare system, we set up essentially an implementation task force. This has been talked about in other news outlets, but part of that task force was to identify critical components of the healthcare system, including clinical, ethics, legal, human resources, public relations, quality and safety, all of these different groups that met regularly over the last 6 or 7 weeks to try and identify and solve for any issues that are raised among any of those areas in order to ensure the best possible care for our patients and ensuring that providers of healthcare feel safe and secure in providing the healthcare that they know is best for their patients. So that system is maybe of evaluation may be unique to my particular setting, but I think thinking broadly, not just about one particular like clinical area, I think is really important because this affects everybody.
Yeah, that's absolutely true. And one of the things the coalition is going to seek to do is get as much information as we can about all the providers statewide. We are a statewide coalition. As you indicated earlier, I think it is clear some of the hospital systems will opt out of any, I mean, some already do. For instance, the Catholic affiliated hospitals, do not provide, they don't provide abortion care. They don't provide basic reproductive care, including having tubes tied, those sorts of things. So we can anticipate they will not provide abortion care, and we know that many people in the state of Indiana live in communities where that is the only healthcare provider. So it creates that additional burden. Can I ask you about cost and how the hospitals are determining? Is there going to be a transparent fee schedule? Because again, it's going to be people who will seek the care that may or may not have ever been a patient at the facility.
Yeah, I don't think that the charges for these services will be reported in any different way from other types of services. So I don't have the exact answer for that question, other than that I don't believe that it'll be different from anything else that a patient may be inquiring about, different costs at different places.
Okay. I've put on the slide here about the morning after pill, which this is your expertise and not mine, but there has been discussion about whether or not the morning after pill is considered abortion care. Thank you for indicating it's not. I'm going to let you tell us how this new law is impacted, if at all, impacting the morning after pill.
So it should not. Emergency contraception is not abortion. The intent is to prevent pregnancy. Different types of emergency contraception do that in slightly different ways, but it is not an abortifacient. It does not cause an abortion. So it should not be affected by the new law. And what I think many people are concerned about, and what we have seen in other states where there are abortion bans, is the risk of sort of fear and generalization of abortion care to other abortion adjacent care, or just other standard obstetric care generally. I think there have been many stories from other states like Texas and Tennessee that have very, very strict abortion bans with almost no exceptions, where patients who have suffered miscarriages or are in the process of developing an infection are denied or delayed services that are required for resolution of that particular pregnancy complication that would not typically be considered abortion care at all. And so while emergency contraception is specifically not included in the new legislation, I think that there is a risk that for folks who aren't familiar with the legislation or may be afraid of what will happen if they provide it, not knowing that it's excluded, may choose not to offer those services.
I appreciate that clarification. I think this is a real issue for those who are victims of sexual violence and who will present, for instance, at a healthcare provider seeking, seeking care as a result of that sexual violence, and that care, can or should include the opportunity to make sure that a pregnancy doesn't result from a rape. And so I think that that's a really important thing for people to understand and for there to be clarity. And what I worry about, of course, is that there won't be clarity around the state. And that's going to be a very, very frustrating and scary thing. Can you talk a little bit about the abortion medication and the notion of receiving the medication through the mail? I mean, this is a legal issue. It's also an interstate commerce issue. And, that's sort of my wheelhouse, although I will have to say it's beyond the scope of what I specialize in. But I think people seeking options, right? And the option of not having to travel to a state that is abortion friendly, getting medication through the mail seems like an option. So how does Indiana law affect that?
So I can tell you that as a provider, a healthcare provider, I cannot provide abortion services via telehealth or through the mail. I would defer to you on if a patient were to obtain medication through the mail from another state, how that would impact that patient. I think it is fortunate as we can be with the current law, that there is no criminalization of patients. So I defer to you on that particular question.
Okay. Well, I think what I can say is that I think it is clearly an open question now about whether whether the state of Indiana will attempt to regulate in any way. What I can say is there was discussion about that a little bit during the legislative process. Some states have considered trying to make it illegal, which I think from a logistics standpoint about monitoring what people are receiving in their mail is a very, very troubling and scary concept, right? I mean, the notion of reporting on your neighbors and having the postal service be kind of in the position of evaluating what you're receiving through the mail this is just a very scary concept. But Indiana does not currently have any regulation associated with that. So at this moment, I can say that that option, if it exists, and setting aside what that means medically, that option legally still exists. All right, Michael, why don't you give us, So there's a lot, again, still unclear. What about minors? What about people under the age of 18? What is this going to mean? Before our special legislative session, there were statutory requirements around issues of consent for minors. If the child's a ward of the state through a CHINS or delinquency, it further complicates the matter. Dr. Rouse, how can you help us unpack some of this?
So abortion services for minors are even more complicated, obviously, than for adults. So starting with the consent process. So consenting for a minor requires a notary signature, which is not something that's required for adults. So that relies on the hospital-based clinic or the provider to have access to a notary in order to legally sign those consent forms. Parental consent is required, although there was a carve out in the final version of the law. If the perpetrator of the sexual assault or the rape or incest is a parent, then parental consent is not required. If the child is a ward of the state, then there is a process by which judicial bypass can be obtained. It is pretty complicated and can be time consuming, which is an additional concern given the relatively early gestational age limit for legal abortion for rape or incest in this state. If the child is a ward of the state, then DCS is involved. The social worker at the hospital where the services are planned to be provided would definitely be involved in order to navigate through that system.
Yes, and reminding ourselves that 10 weeks is not a very long period of time, especially when we're talking about young people whose menstrual cycles may or may not be in a regular posture, and also young people who are additionally vulnerable because of their situation and because of the circumstances surrounding the pregnancy. If it, certainly if it's not rape or incest, then they are not able to access abortion care. Meanwhile, if it is, and they are indicating that that's the case, as a minor, that that their situation is further complicated. So it's a very it's a troubling problem. Someone who is listening in the chat indicated, and I'm going to quote now, the states that I have reached out to, and this is Julie Grable, thank you, Julie, for information are unwilling to send abortion medication through the mail to states where abortion is illegal. That's now going back to the issue of what about medication through the mail. That's an interesting concept that we'll have to see how it plays itself out. There are international providers in Canada, and I think in the UK in particular, who are not subject to American law as it relates to that. And so I think that is another supplier that people will be seeking medication abortion through the mail in an international posture. And I'm the last person who is in a position to advise anyone about that or how that would work. But I just wanted people to understand that that's going to further complicate this situation. Let's talk a little bit about waiting periods. Let's go back to the previous slide, Michael. There we go. Indiana did have an 18-hour waiting period prior to this special legislative session. It was a situation where a person would be given information and potential screening experiences, and then have to come back. So Dr. Rouse, can you help us navigate what how the new law is going to impact the waiting periods, if at all, and what that's going to mean?
So there's still a mandatory 18-hour waiting period. There is an exception to that if there is an imminent threat to the life of the pregnant person. But generally, the person would come in, receive the state mandated counseling. Ultrasound is required at the time of counseling. Patient must verify whether they want to see and or hear the fetal heartbeat at that time. An image of the ultrasound must be included in the patient's medical record. And if it's a minor, all of the appropriate notarization, etc. Then the patient must wait 18 hours before the abortion can be performed or abortion medication received.
So at this point, no changes to those waiting period requirements, other than, of course, immediate health of the pregnant person, which of course wouldn't necessarily impact the rape or incest exception, because it's a separate exception that we will, again, not focus on. All right, Michael, I think we have some questions in the chat about what we're talking about now. Medical providers, social workers, access to abortion where states are still legal. Yeah, the question is, and it's a legal question about healthcare providers. So I think it's going to straddle both of us, Dr. Rouse. But the question is, what are the ramifications of providers, medical providers, social workers, and others who are helping clients access abortion services outside of the state of Indiana? What I can say is that the law currently, as it's written, does not include criminal or even civil penalties for anyone who assists, whether that be a medical provider, a social worker, anyone certified or not, to provide any kind of help to a pregnant person. Dr. Rouse, I know that medical professionals are very concerned about this, right? What can you tell me about what your profession is discussing and how this is working for you?
So I think we are reading the law like you are, which is there is no prohibition on providing information to a patient who is seeking legal abortion services. And so for a patient, as on the first bullet in this slide, is beyond 10 weeks post-fertilization and is seeking abortion care, they may be provided with information for resources on how to obtain that care, where, some specific ideas for sites of care. That is not illegal in our state currently.
It's probably a good time to remind ourselves that when Dr. Rouse says currently, she is anticipating, and I think we all are anticipating, that when the legislative session begins in January, the 2023 legislative session is going to convene like they always do every year. And we anticipate this to be a continuing topic, that we, even though the special session, which by the way was intended, the governor and the legislature intended to deal with issues of finances and taxation, which they did deal with a little bit. They're going to go back into session in January, and we anticipate there will be attempts to make additional changes. And it is not clear, of course, what those attempts will be and whether they will include further restrictions or an easing of restrictions or criminal penalties or non-criminal penalties or other efforts. So at this point, we just don't know. And it's important for us as those who pay attention to this issue to be engaged in January when the legislative session starts again.
And I can say, if I could put on my advocacy hat for a second, I truly believe that the current law could have been worse were it not for the testimony and the presence of people who were advocating against an abortion ban at the State House. You know, there are other states, adjacent states, that have a total, like essentially a total ban with no exceptions, except for imminent threat to the life of the pregnant person. And so I think being engaged at the time of legislative session is super important. Being engaged prior to the legislative session, especially in things like upcoming elections, can be really, really critical in helping to prevent any further restrictions that that might be attempted. The Indiana Right to Life released their survey to legislators relatively recently, that is somewhat of a litmus test for who they will and will not support. And many of the things that we're concerned about becoming legislative priorities for them were on that list, such as restricting abortion to not include fetal anomalies, to not include a health exception, to potentially not include rape or incest. So knowing who your legislators are, contacting them early and often, being involved in the legislative process with testimony, either verbal or written, or, you know, collaborating with other groups is like so important.
That all those things are absolutely true. And we do have an election this year, November 8th. Every member of the House in Indiana is on the ballot, and a third of the senators. And there are plenty of resources out there to find information about that if you are interested. We've got some questions coming in the chat about what we're talking about, so I'm gonna go right to them. Is there a specific definition of what constitutes a fatal threat to the life of the pregnant person? I think this, and I'm gonna of course let Dr. Rouse handle this, but I think this is another example of where clinical practice and the legislative process are not in alignment. Help us, Dr. Rouse.
Yeah, legislating medicine is harder than I think a lot of people thought. So the statute defines a serious health condition as one that increases the risk of death or a serious risk of substantial and irreversible physical impairment of a major bodily function. It very specifically excludes psychological or psychiatric conditions. So a patient who presents with suicidal intent, or having an actual suicide attempt would not be eligible for a legal abortion for the serious medical condition exception in the state of Indiana. In terms of how our medical providers interpreting what does a serious health risk mean, it is hard. There are certainly discussions ongoing amongst providers about how exactly we're going to interpret this. I think using each provider having their own experience, their reading of the medical literature, discussions with other providers, and just using their good faith medical judgment in a discussion with the patient about what are the risks of ongoing pregnancy with this particular medical condition versus what are the risks of having an abortion procedure. that's that's all that we can do. Same thing for a lethal fetal anomaly that's defined in statute as a condition which would be expected to result in the death of the neonate within 3 months of birth. That's not a medical definition. Nobody knows exactly where that came from, how that 3 months made it into the statute. I imagine it was something of a compromise. Somebody said 1 month, somebody said 6 months, they landed on 3. So that again is going to be sort of incumbent upon each provider or provider group to think about those things and to have those discussions with the patients.
Let me also ask, since we're talking about, even though I said we really wouldn't delve too deeply into the issues of maternal health and fetal anomaly, there seems to be a conflict in the way the statute was drafted and passed about how long. The 10 weeks does not apply to this, clearly. The 20 weeks that we previously experienced seems to be referenced somewhere in the statute, but I mean, if it is the imminent, threat to the life of a pregnant person, one would presume that would be up until a delivery. I'm out of my depth. Help us, Dr. Rouse.
So the timeline for the lethal fetal anomalies is 20 weeks post-fertilization. There is no specific time limit on the serious health risk or life of the pregnant person exception. However, what I will say is that the number of times that an abortion procedure would be needed, like a surgical abortion procedure for somebody with a serious health risk, is very, very, very rare. At or after neonatal viability, which is a moving target with medical advancements being able to support smaller and earlier gestational age neonates. Viability is considered somewhere between 22 and 24 weeks post last menstrual period. So if a patient, for example, were to come in at 25 weeks with a life-threatening condition, they would almost certainly undergo delivery of that neonate, either via induction of labor or via C-section. The situation in which a surgical abortion procedure would be needed after that period, that is not something that happens. I know there's a lot of misinformation out there about physicians doing abortion procedures up to the date of delivery, and that's not a thing that happens. Patient specific factors and fetal factors, very, very, very rarely in that earlier of the viability continuum. But I can say that in all of my years of practice, I can count on less than one hand, one hand, what the number of times that's been necessary. And truly to save the person's life.
That is really helpful because I agree with you that there is a lot of misinformation about what the medical process really is and how it plays itself out in the context of providing this kind of care. Well, let's go back to rape and incest, since that's our focus this morning. We've already talked a little bit about supporting those people past 10 weeks who are seeking abortion care. I'm not asking you to speak for your medical provider, the system that you work for, clearly, but do you have any sense of whether hospital systems will be active in providing resources or information, or is that something that the pregnant person will have to seek on their own?
So I can only speak for my hospital system. We have a family planning division that is going to remain active after September 15th, doing consults, giving information. And so that is one potential area that people could look. There was a question about what resources do I think are necessary for people to know about. And as a representative of ACOG, I can email those to you, Beth, so that your organization can have them.
I appreciate that very much. One thing I am going to do on behalf of the coalition and the providers all around the state is seek information from the Hospital Association of the State of Indiana. They are the lobbying and information and training organization, and there needs to be transparency among the hospital systems around Indiana about who is providing these services, who is not, how can we best advise the survivors and victims of sexual violence all around the state of Indiana. Because of the 10 weeks time frame, time is of the essence, as we, lawyers like to say, and it isn't a situation where you can take a couple of weeks to call around and see which hospital is providing these services. We can't expect survivors to be in a posture of having plenty of time, because they don't. And that is really the 10-week restriction that we now know. And that does speak to the next bullet on the slide here, which will provide care and which will not, and how to find out. And I hope, I don't know, but I hope that hospital systems will be transparent and forthcoming with that information. Again, it's not the kind of situation that most of our survivors find that they've got time to navigate that. So I think, Michael, that is the last of our substantive slides. We do have some questions coming in, and I want to go back to this issue of mental and psychological health of the pregnant person. And the question has come in, I think I know the answer, but this is really Dr. Rouse's wheelhouse. So the question is that if a pregnant person has attempted suicide while pregnant and has very specific suicide ideations, that they are not eligible for abortion under the section of health of the pregnant person. Clearly, if it's under 10 weeks and they are the victim of suicide, of rape or incest, then that would apply to them. Do you have thoughts, Dr.
That
Rouse?
is certainly the intent of the law.
Fair enough. There is also, there are lots of comments or questions in the chat about needing information and resources, and that is certainly the role of the coalition. That is the reason we exist, and that is something that I'm going to really put top of mind and top of schedule for me to make sure those things can be made available. Let's see. Are you aware of efforts to create a website or a one-stop shop for abortion access in Indiana? I'm not aware of separate efforts, but I think that may be something that we as the coalition would need to provide. And I think it is not going to be easy. And by that, I mean that the transparency that we would hope the hospital systems would provide to us, not only about who is doing the care, but when, how much it's going to cost, what is the protocol. I keep referring to the emergency room, just because with people with no other sense of what to do, they go to the emergency room, right? And as we know, just in a public health kind of issue writ large, it's the least efficient, least effective, worst way to provide care to anyone. And so the notion of how people who want to seek abortion care are going to do that logistically within the hospital systems is important to know. And I don't yet know the answer. Is there anything else that you think about as it relates to that, Dr. Rouse?
I don't think so. Someone just posted about that the individual state associations provide information to their members. That's something that Indiana ACOG has done. We had our quarterly meeting last week, and that was some of the information that we handed out to folks.
Well, thank you to Indiana ACOG on behalf of those of us who are seeking that information. Let me ask you another question that we've already touched on a little bit about. What do you anticipate are going to be the new efforts in January on behalf of, well, that the legislature will engage in to do more in the areas we've been talking about? What do you expect to happen in January?
I think there will be further efforts at restrictions. So the rape, incest, health exception, and fetal anomaly restrictions were hard won. And again, I think only made it into the final version of the bill because of all of the people who testified and showed up and did all of the work ahead of time to make sure that those actually made it in. But as we have seen from other states, it is not a given that a legislature is going to listen to its physicians and other experts when they say that at the bare minimum, these exceptions are needed in any kind of abortion ban. So I think further restrictions on scope of legal abortion. I think criminalization of physicians, increasing that, I think, will be an attractive topic to some folks. So
Can you help us understand currently that there are threats to a license of a medical provider currently in the law? Were in the law before the special session and continue to be in the law. Can you walk us through that just very briefly? There's been a lot of talk about the recruiting of physicians in the state of Indiana. There's an article in the Star just yesterday about that, and about how hard it's going to be to retain providers and to recruit additional providers. How does the licensing threat work currently?
So any person can bring a complaint to the medical licensing board. You don't have to be in medicine. You can just, any person can raise a complaint. I think you cannot be the AG, but you could maybe be in the AG's office. So they raise a complaint, it goes through the medical licensing board. If the medical licensing board finds against the provider, then I think that you probably know this better than I, but I think specific to providers of abortion services, if they are found to have violated something within the medical statutes, then I believe that is a mandatory revocation of their medical license in the state of Indiana. It is also possible there are criminal penalties for provision of illegal abortion services. It's a level 5 felony, which is 1 to 6 years in prison and up to $10,000 fine. The concerning thing, of course, to everybody who is providing these services or who's making determinations about whether these services are, meet the criteria, is that, medicine is not black and white. There's not one universal list for fatal anomaly or serious health risk that everybody is working off of. Each patient is an individual. They have their own individual life and social and medical circumstances. Every constellation of comorbidities, even if they're the exact same conditions, are going to affect each individual patient differently. And so that's really frightening to providers, which is why one thing I'm worried about is sort of this bleeding out of concern into even non-specifically abortion services, why people may choose not to provide emergency contraception or, be worried about miscarriage management, et cetera. There has been a lot in the news recently about recruitment and retention of good physicians in our state. There was a survey that was done recently at a downtown medical campus of residents and fellows. The survey was out for about 4 days, got a 30% response rate, which is pretty good for that short amount of time. And this was of all physicians of all specialties, physicians in training of all specialties, of all various years of training, above medical school, but before graduation and into independent practice. And 80 to 85% of respondents indicated that they would be somewhat or much less likely to pursue employment in the state of Indiana as a result of the abortion ban and or the criminalization of physicians. So it's real concern, in Indiana, about 30% of our counties are considered obstetric care deserts. So there is no OB provider or OB delivering hospital. And this is definitely not helping.
80 to 85%.
Mm-hmm.
I'm going to let that sit there for a minute. We are, as a state, are going to feel the effects of this. And to your point, Dr. Rouse, about the maternal fetal medicine deserts that we experience all around the state of Indiana, that's going to get worse. And there's been some consolidation of hospitals, as the downtown medical campus and others who have been participating in that, and finding care, not just abortion care, but all kinds of maternal and obstetric care is going to be harder. And that is going to have a real impact. All right, let's go to a couple of questions here in the chat. There are some questions about advocacy, and I am a little hesitant to put on my advocacy hat, even though those who know my background know that I'm all about it and have done it a lot before. There are lots of organizations, including the nonpartisan Women for Change who are in this space and have been very active, and were very active during the special session. It's Women for the numeral 4 change. It's how to access the information. So check out their website for sure. Both political parties have lots of information about the election that we are facing. One thing that Dr. Rouse has indicated about criminal penalties is the prosecutors are playing a role in this. And many of the prosecutors in the state of Indiana are up for election this year. Not all of them, but many of them are. And there has been a fair bit of discussion about what position they are going to take as it relates to any potential criminal penalties, not only against providers, but also against women and people who are helping them. And that is a real issue that requires some advocacy, in my opinion, as well as the legislative elections. Let's see, what other questions do we have here? Something about the State Medical Association and the American Medical Association. Looks like there are some webinars and other opportunities to learn about what the medical associations are doing. I am also, and I will say again, very interested in what the Hospital Association is going to do or not do, and I'm going to be very anxious to engage with them, which I will do. Speaking of understanding the lay of the land as it relates to abortion care, the National Association of Coalitions and the National Alliance for to Advocate Against Sexual Violence, or NAESV, which is the public policy arm of the coalitions around the country, are putting together some good resources about a map of the country and where abortion care is still available, safe, legal, and how a person in the United States who is seeking abortion care can access that, how far away from where they live. We know currently that Illinois is an abortion-friendly state. Ohio is not. Kentucky is not. Michigan is, although there has been a lot of discussion in Michigan. They have a governor's race, a governor's election, among others, and I don't know whether that landscape will change. So as far as anyone in Indiana who is, for instance, serving folks on the eastern side of the state, Fort Wayne, Richmond, down along the river, Ohio is not an abortion-friendly state. If you're on the west side of the state, the region, Terre Haute, down to Evansville, Illinois is an abortion-friendly state. So we will be providing that kind of information as well from a kind of geographic standpoint about where abortion care can be sought. And clearly traveling, especially for victims of sexual violence, is very, very hard. And I'm not saying that that is a panacea, but it is another option that we need to make sure. That's right. Someone just reminded me that Michigan is going to have a voter referendum, although there have been efforts to keep it off the ballot. The lawyers have been fired up about that, but I believe that their Supreme Court has finally indicated that it can go on the ballot. Something to keep in mind. Before someone asks me, I'm going to answer the question of whether I think Indiana would experience a voter referendum on this topic. As we all know, Kansas did that earlier in the summer, and frankly surprised a lot of people with the result, which was that the folks in Kansas pretty overwhelmingly determined that they do want abortion care to stay safe and legal. Indiana has a very different approach to referendum matters. It is not what I would call a referendum-friendly state. Other lawyers on here, Carrie and others, we could talk all day about what that means as far as whether it's good or not good from a public policy standpoint, but what we do know is that putting a referendum on the ballot in the state of Indiana has a very high burden. And I do not anticipate if anytime soon that Indiana would take a referendum to the voters on this issue or any other. But I've been wrong before. So we'll see. But again, that's probably not a remedy if we consider that we want Indiana to be a more abortion-friendly state. Remedies involve legal remedies, of course, referendum remedies for the voters, and then, of course, our legislative process. One other thing that's happening that I should mention, speaking of our legislative and legal process, there are 2 lawsuits, both of which have been filed by the Indiana Civil Liberties, the Civil Liberties Union, Indiana is what they call themselves, ACLU Indiana. One is interestingly based on a RFRA legal posture, which is that people of the Jewish faith and also Hindu and Islam do not believe about this notion of life at conception, which some of our legislators were very clear to indicate was the posture for their thought about this particular law, and that it is a religious violation of their freedom of exercise of religion to have these kinds of abortion restrictions. Interesting legal argument filed in Marion County. We will keep people posted. These are all state court claims. The first lawsuit filed in Monroe County, which is Bloomington, and it is an Indiana constitutional claim, which I find interesting and I don't believe will have success. But the thing I am keeping an eye on immediately is an injunction, or which is the legal mechanism to stop a law from going into effect. Those of you who've paid attention to this issue a lot over the last couple of years may think that we have a really good opportunity for injunctions in the courts, because we have had federal courts that have weighed in the state, in our districts, and those federal judges have issued lots of injunctions against lots of some things that our state legislature has done. We do not have a good forum in the federal courts anymore, because Roe was the underpinning of those federal cases. And so it's a long and complicated question, but we don't have Roe anymore. And because Roe is no longer with us at the federal level, we don't have good federal claims. So what we have now are state claims, and we'll have to wait and see whether we can get a good, well, an abortion-friendly decision. So between now and Thursday, we may have an injunction, and of course, we will let everyone know. Somebody put pro-choice website in the chat. So if people are interested in that, please pay attention to that. We have time for about one more question. So I'm going to invite one more question, and before we can see those in the chat, I'm going to ask Dr. Rouse if she's got any closing comments for us.
I don't think so. Thank you for the opportunity to talk. I think the more we're able to discuss these issues and raise concerns, and definitely with the resources, keep everybody as informed as possible about what is and is not permissible, and particularly resources for patients. We can do the best that we can within the system that we have. Absolutely.
So what happens now? This recording is going to be available. We'll put it on our website. And by the way, our website is ICESAHT.org. So it's ICESAHT.org. That is our website, and we will, Michael will put it in the chat, so we can make sure that this recording is available. We are working on a frequently asked questions document, which will memorialize the questions that were asked today, other questions that we know are out there, some resources and information, and we're going to keep that as a living document to make sure that it is updated as best we know. We will keep an eye out for any injunction that might be issued by either of the state courts. And by the way, just for those who aren't lawyers, an injunction means the effort to stop implementation of the law. So if an injunction is issued, the law will not go into effect. There'll be further confusion. It's a stopgap and potentially good news, but temporary good news. So we'll keep everyone posted about that and make sure that you are aware of what might be happening also in the courts. My final word is I want to say thank you to Dr. Rouse so much, not just for her participation and her advocacy during the session and today, but also for what she is doing to help patients. It is just critical to have our healthcare providers be voices in this process, and you are such an important leader in this area, and I really appreciate you. It is 11 o'clock. I want to thank you for being with us today. To everyone within the sound of my voice, I want to thank you for what you're doing for victims of sexual violence in the state of Indiana, and I want to let you know that you should stay hopeful, because it's the only way for us to really help those who need our help. And with that, I will say good morning, and thank you all so much for being with us today.